Welcome to the ICTY Weekly Press Briefing. I'm Magdalena Spalinska, spokesperson to Registry Chambers, and I'm joined today by a representative of the Office of the Prosecutor, Liliana Pitesza, who is a Senior Information Assistant at the OTP. I'll turn first to a series of decisions issued in the last week. Vice President of the Tribunal, Judge Agius, who was assigned by President Meron to consider Szeszel's motion seeking the disqualification of Judge Frederick Harhoff, issued an order yesterday staying the assignment of another judge to sit on the Szeszel bench. He requested the remaining judges on this case to consult with the accused on the question of whether to rehear the case or continue the proceedings, and to decide, in the event that Szeszel withholds his consent to the continuation of the proceedings, whether or not to nonetheless continue the proceedings with a substitute judge. Judge Agius issued his decision after last Wednesday's finding of a specially appointed panel that Judge Hendrik Harhoff had demonstrated an unacceptable appearance of bias in favor of a conviction in a private letter he circulated on the 6th of June 2013. Judge Harhoff has been disqualified from the case of Wojciech Szeszel by this decision. The remaining judges of the trial chamber, that is presiding Judge Antonetti and Judge Lattanzi, filed yesterday a request for urgent clarification, asking for the specially appointed panel to reveal whether or not it took into consideration the report of presiding Judge Antonetti. The report has been made public today. Judge Harhoff also filed a request yesterday asking the panel why the presiding Judge Antonetti's report and his own memorandum were not on the record when deciding his disqualification from the case. In addition, the prosecution filed a request to Vice President asking for the panel's decision to be reconsidered and, in the meantime, for his decision to be stayed. In the case of Radovan Karadzic, the chamber last Wednesday denied the accused's motion, filed on 1st of July, to dismiss the indictment against him. In the motion, Karadzic requested this dismissal on the grounds that the United Nations Security Council did not have the authority to establish the mechanism for international criminal tribunals, and that accordingly there is no legal entity to which he can appeal in the event he is convicted. The chamber ruled that Karadzic will have the right to appeal the judgment to a legally constituted tribunal, and that as such, the accused's right to a fair trial has not been presently infringed. Also last Wednesday, a public redacted version of President Meron's decision of 25th of July was issued, in which the President granted in part Slobodan Praljak's motion for review of the registrar's decision to reimburse the cost of his defense. President Meron found that the registrar's decision on means was reasonable and was made in conformity with the applicable legal provisions. The President also required the registrar to apply to the relevant chamber, which may then make an order to recover the costs of providing counsel. I'll move now to two early release decisions. Last Thursday, a public redacted version of the President's decision of 10th of July was issued, in which the President granted Dragoljub Ojdanic early release from the United Nations Detention Unit, where he has been serving his 15-year sentence. While the President found that the high gravity of the crimes for which Ojdanic was convicted weighed against his early release, the President granted the application on the basis that the accused had served 2/3 of his sentence, had shown acceptance of his conviction, and had demonstrated good and productive behavior during detention. Late last week, Momcilo Krajišnik was granted early release from prison in the UK following the President's decision of the 2nd of July 2013. In reaching his decision, while the President found that the high gravity of the crimes for which Krajišnik was convicted weigh against his early release, The accused application was granted on the basis of his good behavior during detention, his demonstration of some rehabilitation, and the fact that by the 3rd of August 2013, he had served 2/3 of his sentence. I'll turn now to 2 status conferences that are scheduled to take place today. In the case of Micio Stanisic, Stoyan Żuplianin, status conference will be held at 3 p.m. in courtroom 1. At 3:30 p.m., a status conference will take place in courtroom 3 in the case of Nikola Shajnovic and others. Now, the trial of Ratko Mladic is scheduled for this week and next. Today, a military expert, Richard Butler, is testifying. This is the 137th witness to be called by the prosecution. And finally, in the case of Goran Hadžić, also sitting for the remainder of the week and next, witness Aleksandar Vasiljevic, former Yugoslav army officer, is currently testifying. He is the 72nd witness to be called by the prosecution. That's all from me, Liliana?
No statement.
I'll open for questions.
What's going to happen next in Szeszel?
What's going to happen next in Szeszel? As I just said, there are a lot of filings that came yesterday and today. They're in front of Judge Agius now, Vice President, who is considering them at the moment. And he will take the appropriate decision in due course.
But do I read the right to say Szeszel gets to have a say in whether or not his trial continues? That you're going to ask the accused?
That's following the rules. That's one of the rules of procedure, so it has to be followed. He will be consulted on this. He has the right to be consulted.
And when they talk about continuation of the case, are they talking about starting from scratch, or are they talking about appointing a new judge who could continue with the deliberations and maybe keep on track the scheduled decision judgment?
Yeah, we are talking, as you can see in one of the filings, rehearing the case or continuing the proceedings. So rehearing, that would be starting from scratch, and continuation, that would be continuing from the point that it is now.
Is it possible if he says, I won't cooperate, that the tribunal could say, we're stopping him, he's been in custody for more than 10 years, enough, we let him go?
No, I wouldn't like to speculate now what could happen if something else happens. What is important is to look at the rules, and I think we all have to wait for Judge Agius and the trial chamber to do what they have to do at this point.
And do you think the rules as they exist now cover the situation that has arisen in this case?
I think you can find in the decision of Vice President, in which he says that the rules in questions do not actually provide for the specific situation in which we are finding, and therefore the decisions and the considerations also have to be taken in the best interest of justice, and this is what is happening now.
You mentioned that there is a rule providing consultation with the accused.
Yeah.
Can you tell me which rule is that? That the chamber should consult the accused what to do?
Yes, I don't have the rules on hand. I think it's Rule 15. It's one of the rules. 15 bis. We can consult afterwards.
15 bis is absence of judgment. It has nothing to do with
that. But it's all very clearly laid out in Vice President's decision. He refers to those specific rules.
No, because today Antonetti and Lattanzi said that they don't share his opinion about the rule and what the rule really says, Rule 15 and 15 bis. That's in today memorandum of Lattanzi and Antonetti.
As I just said, as Vice President noted in his decision himself, the rules do not cover specifically the situation we are finding ourselves now. But however, the rules should be applied as closely as we can in the given situation, and the judge will make his decision based on those rules. Are there any more questions? If not, thank you very much, and see you next week.